ensuring that we understand our responsibilities as far as disclosure statements by lessors are concerned. Now, just a housekeeping thing, if you've got a question, please jot it down and send it through, and I will answer it towards the end of the presentation, if time allows. Otherwise, I'll make contact with you at the conclusion of the webinar. Okay, here's my mugshot and a brief explanation of my legal expertise. I am prepared to speak with any registrant on any of the areas of my expertise as detailed here, and invite you to contact me if you have questions in any of those areas of the law. As you know, we are required to make a disclaimer, and the information given to you today is general only and can't be relied on as specific legal advice. The general advice given is not intended to be a substitute for specific advice about a particular problem, which you should refer to your own solicitor. Okay, now that we've all settled down and got our sandwich and our cup of coffee, let's talk about what's happening. Well, the very first thing that's happening is there are proposed changes to the Retail Shop Leases Act. The Retail Shop Leases Act Amendment Bill 2015 was introduced into Parliament on the 13th of October last year. It was introduced in response to the mandatory statutory review of the Retail Shop Leases Act and replaces the 2014 bill that lapsed due to the change in government. The bill was due to be introduced today, however, Uber and taxi licence issues took precedence, and the bill is now expected to be introduced in about 3 months' time. We will let you know when the bill becomes law, and we'll have another webinar highlighting changes to the Act. The reality is, of course, that there might be further changes made, and we may not talk about changes for another 12 months, but one would hope that the changes intended will become law sooner rather than later, and I'll talk about those later in this presentation. Okay, so the first thing that we need to consider is what is a retail shop lease. And you remember back last May, we did these same scenarios, and you can see whether or not your knowledge has improved or whether you knew the answers last time or not. The first scenario is this. We've got a lease of a real estate office upstairs in a 2-storey tenancy comprising 12 retail shops downstairs and 15 commercial tenancies upstairs, non-retail. All lots are governed by a community management scheme. So, and there's a second scenario which is similar. However, the real estate office is on the ground floor of a building with 6 tenancies, 3 retail shops and 3 commercial tenancies, and no community management statement, and the building owned by the one landlord. I will hark back to this scenario in a minute, but what I want to do first is actually go through some definitions in the Act so that you can see why the answer is what it is. So when we look at the Retail Shop Leases Act, the first thing we need to look at is what a retail shopping centre is. So if you look at that, you'll see it's a cluster of premises having all of the following attributes, and I emphasise all. It's and, not all. So A, 5 or more of the premises are used wholly or predominantly for carrying on retail businesses. B, 1, all the premises are owned by one person, or 2, have one lessor or head lessor, or if the premises were leased, would have one lessor or head lessor, or 3, comprise lots within a single community title scheme. So B is or, not and. The and is A, B, C and D. In C, all of the premises are located in one building or two or more buildings if the buildings are joined, and if the premises are owned by one person, the buildings are separated by common areas or other areas owned by the owner or a road. Or C, if the premises are not owned by one person, the buildings are separated by common areas or a road. And D, the cluster of premises is promoted or generally regarded as constituting a shopping centre, shopping mall, shopping court or shopping arcade. So that's the definition of a retail shopping centre. The next definition that we need to consider is what a retail shop is. It means premises that are situated in a retail shopping centre or used predominantly, wholly or predominantly, for the carrying on of one or more retail businesses. Now, a retail business means business prescribed by regulation as a retail business. And I can assure you that a real estate agent's office is not prescribed as such. So the answer should be becoming quite clear to you. Then the definition of a retail shop lease means a lease of a retail shop other than a lease of, then we go through all of those things. A retail shop with floor area of more than 1,000 square metres by a listed corporation or a listed corporation subsidiary. South Bank Corporation, premises in a theme park, flea markets, agricultural trade shows, carnival, festival or cultural event. Premises that would be premises within a common area of a retail shopping centre, but only if the premises are used for one or more of the following purposes. And another type of premises prescribed by regulation. So, going back to those scenarios, scenario 1, lease of a real estate office, upstairs, 2-storey tenancy comprising 12 retail shops, downstairs 15 commercial tenancies, non-retail, all lots governed by a CMS. Is it a retail shop? We're going to conduct a little poll on this now, and I want you to have a think about it and provide the answer. This is only in relation to scenario 1 at this stage. We have about 20 seconds, thanks, to vote. 71% have voted. %82% have voted. There's no way of us checking on you, so come on, put your answer in. Okay, 5, 4, 3, 2, 1. 88% voted, 12% abstained. 67% said yes, and 33% said no. The answer is yes. Scenario 2, different circumstance, different setup, having regard to those definitions, yes or no? Start the poll now. Okay, 71% have voted so far. I'll close the poll in 5 seconds. Okay, close it off now. 85% said no, and 15% said yes. The noes have it. Well done. The next thing I want to talk about is a retail shop tenancy agreement. As you know, so far as the tenancy documentation is concerned, the REIQ present a document which is before you at the moment. And I'll repeat what I said last time, this is an excellent document. However, it has limited use. What do I mean by that? There's a nice big red warning, do not use this agreement, A, for residential tenancies, pretty obvious. If the premises are not a retail shop under the Retail Shop Leases Act. If the term including options is greater than 3 years, and what that means is if it's a 1-year lease with a 3-year option, you don't use it. If it's a 2-year lease with a 2-year option, you don't use it. If the sum total of the years including the options is more than 3 years, do not use this document. If either party requires the lease to be registered under the Land Titles Act 1994, in relation to that, we'll put the other one up, it's a tenancy major lessee, so let's not worry about that, we're talking about Coles and whoever. But in relation to D, there will be a number of tenants and a number of landlords who do want the lease to be registered. If that's the case, then you cannot use the REIQ form of tenancy agreement. You must use a lease, which is prepared in what we call Form 7 and is capable of registration at the Land Titles Office. In relation to that, it's not your call to do that. It's the call of the landlord or the tenant. And I think if you've got any pro forma documents out there, you must ask that question. Does the landlord require it to be registered or does the tenant require it to be registered? And if the answer to that's yes, then we go to the lawyer acting for the landlord and tell him to prepare a lease. Now there might be a cost involved in that, but if there is a cost involved in that, so be it. Amortise it over the life of the lease and you'll see that the costs dissipate into next to nothing. And of course you can't offload those costs to the tenant other than certain things like survey, registration fees, mortgagee consent, which I'll talk about later. I have put up as well, like I did last time, the commercial tenancy agreement. And again, this is an excellent document. And it would have been perfect to use in a scenario where we had that real estate agent's office in scenario 2, if it was, for argument's sake, for 3 years or less, including options. It is an excellent document, I'll repeat that. However, again, there's a warning up there which says this. You can't use it if it's a residential tenancy, obvious. You don't use it for premises covered by the Retail Shop Leases Act, pretty obvious as well. As I just said, where the term of the lease including options exceeds 3 years, and where registration under the Land Title Act is requested by the tenant. As I said at the outset, something we didn't concentrate on at the last webinar and which I think we need to concentrate on as agents for our landlords is what our disclosure requirements are. They're not difficult, but they are fairly comprehensive. And Part 5 deals with preliminary disclosures about leases. And it doesn't apply to a retail shop lease for a periodic tenancy. A periodic tenancy would be where the landlord and tenant have an arrangement where the tenant goes in and is paying monthly rent and hasn't got a lease agreement, God forbid. So it doesn't apply to that situation. tenancy at will, which is even worse, where the landlord just lets the tenant go in and he pays rent when he feels like it. I hope we haven't got too many situations like that out there, because any of those situations that are created end up in court. And it says, or a retail shop lease entered into or renewed under an option. So if there's a 3x3 lease, for argument's sake, and the tenant exercises the option, there's no need to comply with Part 5 disclosure requirements. However, in the new legislation, believe it or not, there is going to be a provision that you do have to comply with that. I'll come to that later. Sections 22, 22A and 23 do not apply to an assignment of a retail shop lease. And that 22 deals with lessor's disclosure obligations. 22A deals with prospective lessee's disclosure obligations. And 23 deals with lessor being required to give a certified copy of the lease to the lessee within 30 days. I've already mentioned section 22, and you do need to give a copy of the draft lease, and you do need to give a certified copy of the lease within 30 days of signing. Otherwise, there's a penalty of 40 penalty units, which could run into quite an amount of money. I decided I'd put up section 22 of the Act so that we can just quickly go through it. It says at least 7 days before a prospective lessee enters into a retail shop lease, the lessor must give to the person a draft of the lease and a disclosure statement. Then it says subsections 3 and 4 apply if the lessor doesn't comply with the section, or if it's a defective statement, the disclosure statement. If you look over at 8, it says a defective statement means a statement that is incomplete or contains information that is false or misleading in a material particular. So if you fail to comply with subsection 1 by giving a disclosure statement and a draft of the lease, or you give a disclosure statement which is defective, then under 3, the lessee may terminate the lease by giving written notice to the lessor within 6 months after the lessee enters into the lease. And 4, the lessor is liable to pay to the lessee the reasonable compensation decided by way of the dispute resolution process for loss or damage suffered by the lessee because of the non-compliance or defective statement. Now, if you get it wrong as the lessor's agent, the lessor has got those obligations, but the lessor will come to you and say, my tenant has walked out because you didn't give proper disclosure. My tenant has walked out maybe because you didn't give him a draft copy of the lease. I'm holding you responsible, and then you get sued for damages. And the lessor will win. So what I'm saying to you now is that if you don't have a pro forma of what needs to be put in a disclosure statement, and if you don't have a method in place whereby you make your landlords give you information to ensure that you can give the disclosure statement and ensure it's not defective, I suggest you do so. The rest of that clause I won't go into, given that time against us. Read it, please. Under section 22D, you need financial advice reports and legal advice reports, and on both in relation to new leases and on assignment. Now, what I've done here is given you a disclosure statement, which I'm sure you've all seen before. But please be warned, it's very easy to present a document which is defective. Every single item in the disclosure statement must be completed. in the key disclosure items, where it talks about the rent payable under the lease, you must put in the amount per annum at the start of the lease, and you must say whether it includes or excludes GST, so that the tenant is aware of exactly how much money the tenant needs to pay over the first 12 months of the lease. If you're in one of the Coles leases or the Westfield or wherever, and its rent is based on turnover, you must say yes. If it's not, you must say no. Don't leave it blank. If it's not a gross lease and the tenant is obliged to pay outgoings, you must give them details of the total outgoings, which will become apparent later on in this disclosure document. If the answer to that is no, put that in, put nil or put 0. The term of the lease is pretty obvious. The estimated commencement date, estimated handover date must be completed. If there's an option, you've got to put yes or no. The next one about exclusivity. A lot of agents just leave it. Don't worry about it. I mean, if the representation was made, we're going into a small complex and you are going to be the only jeweller in the complex, and you make a throwaway statement about that, and then you put no, then the tenant's going to have an action against you. So be careful about what representations you make. When you come down to the premises, all that information must be put in. Be specific about the address of the premises in number 1. Be specific about the actual real property description in number 2. And actually have a plan attached. Now, if it's the whole of a lot, for argument's sake, in a community title scheme, it's lot 2 on SP 546. Put the CMS plan in, or the SP in, I should say, and highlight it. So that's it, you get the whole of the lot. If it's not the whole of the lot, and it's going to be subject to survey, you must have some sort of sketch plan to put in there so the tenant knows exactly what they're getting. And you must put in 1.3 what the actual or estimated area is. 1.4, it says select as appropriate. This is about one of the few places in this document where you actually tick or leave. So for argument's sake, if it's got air conditioning, tick it or cross it. If it's got a cool room, doesn't have a cool room, leave it blank, etc. Anyway, look, I don't want to tell you how to suck eggs, people, but really this document is just so important and it must be filled out accurately, otherwise it will be a defective statement. And my suggestion to you, as I said before, is I would send this to my landlord and say, I want this completed to the letter, and when you've completed it to the letter, I'll then be able to do it up in final form and send it off to the prospective tenant. If we just flick over to the next page, if there's works and fit out and refurbishment to be done, explain what it is. Add an extras if you have to. In relation to the rent, be specific about what it is, because the tenant needs to know exactly what it's going to cost him to operate that business for the next 12 months. If you don't do it, the tenant can walk away. The outgoings estimate, if it is in fact a gross lease, you can just say not applicable at the top of it and forget it. But if it's not a gross lease and they're paying outgoings, you must detail exactly all those things in there. And for argument's sake, if it doesn't apply, you can put not applicable, but don't just leave it blank. The other costs, again, don't leave it blank, so not applicable, or put them out in there. Trading hours, always a bone of contention, but some people don't understand exactly what happens in the with the legislation. The Trading Allowable Hours Act basically caters for that. I won't go into that today, but I think if there are core trading hours, you should explain what they are. The centre details, this is important. You must tell them how many shops there are, the gross lettable area of the entire centre, if it's in a centre. If they're not paying turnover rent, I believe you don't really need to talk about the annual turnover of the shopping centre, although they might be relying on that to see whether or not they're going to enter into this lease, because there might be some representations made, so think about that. If there are major tenants in there, you must disclose that. For argument's sake, the one with Dolphins down here at Redcliffe was disclosed, obviously, that Coles is a major tenant, and that basically is a catalyst for a tenant to want to go in there because it brings people to the area. Make sure you give them a proper floor plan. If you don't have customer traffic flow information, tick no. If you do have it, give it. Okay, without going into too much more, item 30 is just so important. If you sign that as agent without the landlord actually signing off on it and saying yes, it's correct, and there's an error, you'll pay for it. It's important that the lessee acknowledges and signs Part 12, and it's important that you do put those attachments there which are set out. The plan of the premises, any additional attachments you have if you haven't got room to complete them within the form. Okay, enough said about that. Once you send out that disclosure statement with a draft copy of the lease, well, if you do it or the lawyer does it, whoever does it, they must send out, or they should send out, a lessee disclosure statement or ask the lessee solicitor to make sure they complete one and send it back. Because there's a requirement under section 22A of the Act for the lessee to give the lessor a disclosure statement. It's a paper war. The financial advice report, the lessee must go off to his accountant or her accountant or its accountant and produce a copy of the lease, the draft lease, a copy of the disclosure statement, and get the accountant to sign off on it. You'll be pleased to know under the new legislation, it's intended that you can walk away from some of the reports. However, the lawyer has to give a certificate to say that is explained the fact that you're waiving the giving of the report. So I don't think we're going to be any better off, to be honest. So we're stuck with this at the moment. We'll keep doing it. The legal advice report, must have it. So really, when a tenant and a landlord say, I'm only going to put Betty Smith into a dress shop of 60 square metres in a retail shopping centre, and she's only going to be paying $18,000 a year and no outgoings, here's a retail shop lease done under the REIQ. Is it okay that she just signs off on it and get on with it? The answer is no. You've still got to get all those reports down. Lessee disclosure statements, legal advice report, financial advice report. If the tenant won't sign it, do everything in your power to make them sign it or get it signed by a lawyer or a financial, by an accountant. At least point out the fact that they're obliged to do it If they don't do it, they can hardly turn around later on and sue you on the basis that you didn't give adequate disclosure. You've got to give disclosure statement, or your client has disclosure statement, draft copy of the lease. Then it's up to the lessee to do certain things. And if they refuse to do it, you can't be held responsible for that. There are situations, of course, where you've got a business which is being sold, and that's where this assignable disclosure statement comes into play. As it stands at the moment, as you probably also know, providing you've complied with all your notice provisions and disclosure provisions, if an assignor sells to another party, the assignor can't be held liable for the rent into the future if the new buyer happens to go broke. However, if the assignor, the seller, was a company and the company's directors gave guarantees in relation to that, the guarantees still remain in place. Apparently that's been looked at in this new legislation, which we hope comes through in the not too distant future. Just remember, if you do have an assignment, you've got to give an assignor disclosure statement, and that means there's also a lessor disclosure statement, an assignee disclosure statement. The paperwork's just mind-blowing, actually. It goes on and on and on. But if you follow it systematically, and you just follow what we put in our paper presented to you here today, you can't go too far wrong. Okay, just recapping on some of the things we spoke about last time, and for those who are new to this and weren't at the last webinar, one provision that a lot of landlords and tenants are unaware of is section 46AA, where renewing a lease if there's no option or other agreement. So that section applies if a retail shop lease A does not provide for an option on the lessee's part to renew or extend the lease, and is not subject to an agreement for its renewal or extension. The lessor must offer the lessee a renewal or extension, or tell a lessee the lessor does not intend to offer the lessee. The lease automatically extends by 6 months. However, the lessee's got a positive obligation under that provision in the Act I just have to find that section. It's a provision in the Act that's not well known, and if you're acting for a landlord, you should point out to them section 46AA, or their lawyer should point it out to them. And the rest of them on my slide there is pretty self-explanatory. Okay, next we've got the provisions implied in retail shop leases, relocation. Then there's how the lessor takes relocation action, termination notice by lessee or deemed acceptance if he doesn't like the relocation notice. You can't contract out of this, by the way. The terms and conditions of the new lease, they can't be agreed to, the lessee can walk. The lessee's got entitlement to relocation costs, including legals. And the lessee's got the right to independent legal advice. The landlord can't make them go and see their lawyer. The lessee's liability for costs associated with preparation, etc. of the lease is limited in those circumstances. And section 58 talks about releasing an assignor from the lease, is what I've spoken about already. When we talk about rent and outgoings, just remember that if you've got a retail shop lease, they must be certain. It's got to be review to market or CPI or fixed formula, and can't be a combination of those. You can't say whichever is the higher, whichever is the lower. The landlord cannot recover land tax, expenditure of a capital nature, contributions to a depreciation or sinking fund, insurance premiums for loss of profits, contributions to merchants associations or centre promotion funds, payment of interest, or any other item prescribed by regulation. Okay, just quickly on rent review. Section 27 of the Retail Shop Leases Act and the reference schedule of the Retail Shop Tenancy Agreement deals with rent review. I won't spend any time on that because we are running out of time. I'm sort of hoping there'll be some questions, which I haven't seen any yet. In relocation that we spoke about before, that is covered in the REIQ Retail Shop Tenancy Agreement in Clause 17, so all those provisions I spoke about before are pretty well drafted and covered. And demolition, the same thing. It's covered by Clause 18 of the REIQ Retail Shop Tenancy Agreement, and there's sections of the Act that apply to that, which you can't contract out of. They're implied in retail shop leases, and what REIQ have done in this is pretty good. There are provisions there about how the lease is terminated by the lessor or termination by the lessee, and the compensation payable by the lessor in the event of a termination. Trading hours we alluded to before. At the end of the day, find out from your client exactly what the client's intention is, and talk to the lawyer acting for the landlord in relation to exactly what and what they can't put in the lease in relation to trading hours. You can't make someone trade if it's prohibited by the Trading Allowable Hours Act 1990. And there's certain exempt shops and independent retail shops that must be bound by the provisions of that Act. There is provision in the Act about mediation, which I find sometimes useful. Just be aware that there is that should say REIQ Retail Shop Tenancy Agreement, not residential, I'm sorry. Yeah, that's all okay. I'm sorry I rushed through that last part, but I know that you didn't want to be stuck on the phone, stuck listening to this for too long. If there are any questions, please pass them on. I don't see any here at the moment. I thank you for taking the time to listen to this afternoon, and if I can help in any way, I'm happy to do so. So where to from here is up on the slide. Look forward to letting you know what happens in this interesting area of the law when the government decides to put through the new Retail Shop Leases Act. Now I've got a question here which I'm trying to read. If you do not include GST in the rental amount on the disclosure statement and the owner is registered for GST, does this mean that the tenant only has to pay the amount identified in the disclosure statement? Potentially yes, because it's an all-inclusive amount. I mean, the tenant's thinking that that's what I'm paying. They're thinking it's including GST, so what you should put on the disclosure statement, as we said before, it actually says in item 3, including or excluding GST. So if on the disclosure statement it said excluding GST, no problem, but if it said including GST, well, he has got a problem. Next question, should the agent obtain a copy of the assignor and assignee disclosure statements? Okay. Okay, I'm just trying. Sorry, this quite difficult to read the question. You don't have to, but at the end of the day, it would be a good idea. If there's lawyers acting for both parties, then I believe that you don't have to do that. But if, for argument's sake, there's no lawyers involved and you're the intermediary in this whole thing, absolutely yes. Next question is, if it is a retail shop lease that is not defined as a retail shopping centre, do you have to complete that section of the disclosure statement or complete as not applicable? I'd put a statement in there saying it's not a retail, it is not a retail shopping centre. I'd just say that. Julie, thanks. And Stephanie, trading hours if owner and tenant agree to hours outside of the Act. Is this okay? No. The answer is no, because you can't trade outside the hours allowed under the Trading Allowable Hours Act. They're both committing an offence. Okay, thanks for those questions from Stephanie and Julie and Jessie and Julie again. That's it. Well, I hope that's been helpful. Good luck, everybody. If you need any advice on retail shop lease issues, by all means, give me a buzz. Thank you. Thanks for attending.